Joining me live in studio right now is defense attorney and legal analyst Barry Covert. Thank you so much for being with us. We know that this is a serious and kind of a topic that, you got to take lightly, right? For some people, certain forms of sexual assault now classified as rape. What does this new law actually mean and do?
It really does two things when it comes to how it now expanded the definition of rape under our New York State penal law. It expanded the areas of our body that are included that can be considered to be rape. Traditionally, it was when it was traditional intercourse. Now it expands it to the mouth and to the two private areas as well, so it does not have to be the traditional form that we've seen in the past. In addition, it does not require penetration anymore. Now it's just simple contact with those areas for that purpose is now considered to be rape, which now takes away the argument in some cases saying, well, I didn't complete the act, so I didn't engage, it was not actually a rape technically. That has now taken that away. Contact is now sufficient to be considered rape.
It's serious. One of the bill sponsors referenced the LGBTQ community. So does redefining it make it easier for members of that community, that group, to move forward, to come forward?
Absolutely. We expect that it would, because in some instances they did not engage in the traditional acts of sex. So now we have the different methods that are now going to be utilized, where it's just a contact with your private parts, with the private areas. Does not have to be the traditional method of doing it. It's contact to those three areas that now would be consistent, would now establish a rape charge.
This is something that people need to know. It may be difficult to hear, but it is important information. What have you seen in the courts with clients and just with trials that have gone on? Is it hard for a jury to come up with a guilty verdict when it's rape because of the way the law is written?
The way that the law is currently written, you have to have the actual proof that the act occurred. It went beyond just contact, that there was actually that. And so where there's a claim that, well, I may have tried to do it, but I didn't actually do it, didn't complete the act, that was a defense, and that could be very confusing to the jury as to at what point now is it rape. So now that makes that much easier. Now it's simple contact. Once you have contact, we have it completed. We also have additional, because now it can be done orally or with your two private areas. So now you've got a large expansion. Those were sexual abuse in the past, now they're rape. And so it's a great broadening of the rape statute. Information
we need to know, because it's on the books right now and it goes into effect September 1st. That's what we heard from the governor today.
That's correct.
Legal analyst Barry Covert, as always, thank you for your insight and for coming on the 530 today. We appreciate it.